Thank you.
SJC-11293, Alicea versus the Commonwealth.
Let's proceed. Good morning.
Good morning, Your Honors. Dakota Martin on behalf of Luis Alicea. In this matter, we're appealing a decision from the Superior Court of Massachusetts where the matter was dismissed on summary judgment. And I hope after you hear from me, you'll agree that this matter shouldn't have been dismissed. I'd like to start with the facts, if it pleases the Court. In 2003, Luis Alicea was charged with 3 gun charges under Mass General Law 269, Section 12E, which is discharge of a firearm, 269-10G, which is the felony enhancement. I believe that carries 10-year mandatory minimum and up, depending on what your prior offenses were, and 269-10H, which is possession of a firearm in your home. And Mr. Alicea was represented by the public defenders. Mr. McGuire was his attorney, and opposition or opposing counsel was Mr. Kane. They came to an agreement for a plea. I believe it was around 2004, and Mr. Alicea agreed to plead to 269-10H, possession of a firearm without a license in his home. They laid the foundation in the plea colloquy, the facts which surrounded the case.
Well, the plea colloquy doesn't talk about a home at all. It's the shots outside.
Yes, Your Honor.
I mean, he didn't really plead to 10H, did he? I mean, on the facts?
Yes, I do believe that he did, Your Honor.
Specifically to 10H or specifically to a lesser included of the G and to 3 to 5? I don't see anything in the colloquy that does anything but talk about a shot from the back, another shot outside, and then footsteps that were wet inside, and he agreed.
Certainly, Your Honor. I was try to familiarize myself with this case.
I think what you're saying is the subsequent agreement and the indictment that was changed was H. But when you're saying he agreed to, and there's no, actually I don't see anything in your argument that suggests he doesn't really deny that he understood that there was an agreement to 3 to 5.
I had a difficult time. I went over the record thoroughly. As I was about to say, I didn't represent Mr. Alicea. I had the privilege of being asked to take this argument. I did my best to wrap my head around the confusion. But what my understanding was, and I could be wrong, but my understanding was that they were painting the picture, the plea colloquy, they were laying the foundation, the facts, and it ended with the officers knocked hard enough to open the door where they found Alicea passed out on the floor. It was either alcohol or drugs, and there was a gun. So I guess what made me think that they didn't lay the foundation for the possession of a firearm outside of the residence. My experience as a public defender in New Mexico, we would when you lay the foundation in the colloquy, you don't tiptoe around the facts, and there is no. You want to really get it on the record. And in my opinion, there wasn't the facts didn't support 10A.
Let's lay this out a little bit.
Certainly.
I gather that what you're suggesting should have happened is that Mr. McGuire, when ADA Kane spoke to him, should have said to him, "No, you made the mistake. You're stuck with it. It's 1 year. I'm not going to sign anything or do anything."
Not necessarily, but what I think.
So what should he have done then?
I would hope that a public defender would at least not only relay the information that he found. I believe the jail called District Attorney Kane to tell them about the error. that they had pled him to 1 year. He had already served 380 days or so pre-confinement. If I was on the case, I would have at least relayed
Okay,
that.
so let's assume he does that, and the defendant says, I want to get out. 1 year is 1 year. He made a mistake. He has to live with it. Could 88 Kane then have brought other charges under 10A?
The state will argue that he could, and I don't think that they could have, and here's why. I believe that, as I said, 10G is the felony. It's an enhancement on 10A, 10H, and a few other gun charges. I also believe that 10H may be a lesser included crime in 10A, and why I believe this is in 1998, the legislature removed language from the law that said 10H explicitly. 10H is not a lesser included crime in 10A. That was removed completely. There's also a case which was not very clear on the matter. I believe it was Jones. Excuse me one moment. Commonwealth versus Johnson, 447 Mass, 1018. It's not extremely clear on the matter. Actually, it's not clear at all. But I thought it pointed to 10H being a lesser included crime, and I certainly agree with the court and the law that if a matter is dismissed, noli prosecuted, if you will, that is without prejudice and it could be brought back. But it's my reading of the record and the case in its entirety that with the facts as they were laid down, they didn't support the 10A, and even if they did, which I don't believe they do, because it's a lesser included crime, I don't believe that could be brought back.
But your focus on the facts is that you're saying he's passed out, although the colloquy is just that after they heard the shots, they come in the house, he's extremely intoxicated, and he's lying down with a gun next to him.
The whole colloquy of
Which all suggests that somebody who had the gun, if that's the gun, and I don't think there's a dispute, was shooting outside. So the fact part doesn't support your argument.
I agree to a point, Your Honor, and I'm only basing this on my experience. If I would want a clearer fact pattern. As I said, I don't try not to tiptoe around the foundation when you're laying the foundation for pleading someone guilty to a crime or to a crime. So that was my reading. I didn't think it was clear enough. Based on the amendment to the rule in 1998 and case law, and the fact that the attorneys in a deposition, I believe they discussed lesser included crimes. At least they did say that 10A was lesser included, or at least 10G was an enhancement. So it was a little confusing, but I feel fairly confident that they shouldn't have been able to bring those charges back.
He pled to 10, at least as listed, it was 10H, correct?
Yes, Your Honor. Yes, go ahead.
So I guess I'm just wondering why, because 10G was null-prost, why that couldn't be brought back with respect to activity outside of the house.
Why 10G could not be brought back?
I mean, that's I think the argument, isn't it? That was what was null-prost by mistake.
Yes, Your Honor, and as was 12E, but 12E carries such a small sentence that we're not arguing about that. Well, 10G as an enhancement
I mean, wasn't the original plan, if it had gone as at least contemplated, was that the DA was going to amend and charge under 10A as opposed to 10G.
Well,
that's my understanding.
I'm viewing this just as Your Honors are. I wasn't there, I couldn't tell you what the plan was. I didn't even handle the appeal. But there, I have some. It's hard to tell whether the district attorney and the public defender meant to plead him to a 10A,
Yeah.
or whether they meant to plead him to a 10H and didn't know that it carried.
That's
Neither one
highly,
of-
highly, highly doubtful that they didn't know what the 10A limit was.
Neither one of them suggests that that was where the error was. There was some misunderstanding about what the nature of the error was. So defense counsel thought, oh, gee, he didn't null-pros the 10G. And so he agreed without looking, and bad, should have looked, should have talked, said, fine, let's amend so that we can get what we thought we got, which was 3 to 5 on the 10A. And that one, the 3 to 5 was, says, I don't think two people, prosecutor and defense counsel, colluded, as there's a suggestion of conspiracy, that they were going to do a 10H and still give them 3 to 5.
No, Your Honor, I don't think there was collusion either.
Right.
But as I said, I can't say what they intended. I know that they pled. They didn't even say what it was. They said count 3.
They didn't say what it was. That would have been clear at a colloquy if they said 10A,
Certainly.
10H. People would have picked it up. But they did recite the facts, agreed to, and then agreed to the deal, 3 to 5, not 10 years.
I agree that
Those things happened, right?
things did
Okay.
happen. And what I'm arguing is, regardless of intent, and I can't say, I'm not really leaning either way, whether they meant H or A, I don't know. They pled him to a charge that carried 1 year. I believe in 2006 it was amended to 2 years.
Right.
But they pled him to a charge, so that's an illegal sentence, and we're not here to discuss their actions. We all know that they shouldn't have just amended the indictment. But what I propose is that
Isn't part of the claim, if there is a claim here, one, from your client would have to be, I thought I was going to get a year, and here I am. I didn't get a year. I'm in here for several years more than that. He doesn't say that. He said he learned later he should have gotten a year. And knowing that this malpractice has resulted in my lengthy incarceration beyond, several years beyond what I thought was what I was getting, I was damaged. And with respect to that, there's another question. Where's the damage to him, his experience, when he says, gee, my concern was 10 years?
Yes, Your Honor. I feel the damage was, Luis Alicea pled guilty. He took responsibility for his actions. They pled him. He ended up, at the end of the day, pleading to the charge of 10H.
Can I just ask you, did he end up at the end of the day agreeing to 3 to 5?
In front of the judge,
Yeah.
when the judge asked for the sentence, they said 3 to 5.
Okay.
Yes, he said
Okay.
yes. But that's when they had to amend it to match.
I understand.
So I guess my argument would be that although he, at the time, pled to 3 to 5, the charge he pled to carried 1 year. So his actions, that of committing or allegedly committing a crime and pleading guilty to that crime, yielded 1 year, or if you want to go by the new rule, 2 years, and which would be 365 days. The harm after that was not caused by his actions. And I'm certainly not asking the court, nor is Attorney Diviaki, who gave me this case, asking the court to overturn Glenn Viakin or any of the other cases on point. It's important to, for all the reasons, all the public policy reasons in place, to have actual innocence as a necessity in a criminal malpractice case. It is a higher standard. It's my opinion that this is a very small window. This is a sentencing matter, and we're just asking that attorneys stay active and stay on the matter. And he has no other recourse. There's immunity, and he's not asking, as I said, he's not asking to benefit from the criminal action.
Thank you.
Thank you. Do I have any more time, Your
You
Honor?
do. You have 27 seconds.
Just as to issue preclusion, I would just like to say the issue hasn't been completely litigated. It wasn't essential to the decision on the summary judgment decision. And thank you all. It was a pleasure to be here.
Thank you.
Good morning, Your Honors. May it please the Court, Sarah Joss, Assistant Attorney General on behalf of the defendant, Pelley, Commonwealth of Massachusetts. We would urge that this Court affirm the trial court's grant of summary judgment for the reasons identified most recently by Justice Duffley and Justice Botsford, namely that the plaintiff in this case was not injured. He got precisely the deal that he begged his public defender to work out for him. He was facing a mandatory minimum sentence of 10 years and agreed to a plea deal that would secure him a 3 to 5 year sentence, which is precisely what he got.
If I can turn you to the second ground that was relied upon by the judge, which is the absence of any actual innocence. And let me give you a scenario which is a little bit different from this, but arguably could have happened. He was supposed to have pled to so much of 10G as would be a violation of 10A.
Correct, Your Honor.
Let's assume he had done that correctly. All right, he had pled to so much of 10G as would be a violation of 10A, with the understanding that the 10G count would be that the indictment would be amended to only charge 10A, and that upon the sentence of 3 to 5 years, it would be clear that he had pled to and been found guilty of 10A. Let's assume that there was a mistake and it said 10G, and the prison authorities see 10G, they know that's 10 years, and they keep him for 10 years. And the attorney does not do anything to assure that he does not serve a longer sentence. Would the defendant in that particular case be barred from a malpractice suit against his attorney?
I think the question at that point becomes, when did the relationship with the attorney end? Because the first element of a malpractice claim would be the existence of an attorney-client relationship. If the attorney-client relationship ended at the sentencing and and no one raised to anyone's knowledge, either to the criminal defendant or to the attorney, the existence of this problem with the NOLPROS, with the indictment, then I think that the question then becomes, when does that relationship continue?
Well, let's assume the minimus says 10G, which is what, of course, goes to the prison.
And in this case, the issue was that the minimus said something other than what the parties intended. And I think the question there becomes, is the claim more properly brought against the Department of Correction or against the public defender? And I think if we're looking at whether or not a malpractice claim would exist against the public defender, I bring it back to the first question in Glenn, which is the existence of the attorney-client relationship.
Okay, let's assume there is one. Are you saying the question is, would actual innocence bar it?
I think the public policies that this court has articulated in Glenn would have to be considered in that situation, which is a very obviously different situation than what we have with Mr. Alicea, which is that he agreed to a particular plea and sentence and received that sentence.
But
I think in
why?
that case, when you'd have to apply the particular public policy concerns, and obviously I can't articulate what a bright line rule should be on behalf of the Commonwealth, I don't have that authority, but the court would need to look at what are the particular policy considerations identified in Glenn, namely, do we want the criminal defendant to benefit either directly or indirectly from their own criminal activity? And then I think the question becomes, applying that public policy concern to the situation Your Honor has identified, what did the plea colloquy support? Here, the plea colloquy supported a 10A plea. I think the question would be, did the plea colloquy support a 10G plea? If it didn't support the 10G plea, then perhaps he would have something. But here, it's a very different factual circumstance in that the colloquy does support the sentence that was imposed. And then, of course, there are the other concerns identified in Glenn, the public policy concerns.
So do I hear you to say that there may be circumstances in which actual innocence would not be a bar, but this is not one of them?
This certainly is not one of them, and I don't think the court needs to reach whether or not there would be circumstances circumstances in it because the factual circumstances in this case are so vastly different from a situation where it's conceivable that maybe it wouldn't be required, that anything that the court did on that point would be beyond the scope of what this case requires the court to rule on, and therefore wouldn't necessarily, well, certainly persuasive, would be at most dicta, and perhaps it's better.
Well, it doesn't, but I mean, one might say that the public policy that's expressed in Glenn itself doesn't, well, I guess I think it just doesn't have the breadth as I think the second reason of the judge suggests, that in any case where no matter what the circumstances are, that a defendant cannot proceed unless he shows that actual innocence. And I just don't think that Glenn supports that. So it seems to me one would have to say something about that, don't you think?
Well, that there may be circumstances, Your Honor, in which the innocence requirement isn't necessarily justified by the public policy that underlies Glenn. That they simply aren't this.
No,
case.
I appreciate that fact. I just think that's your argument. I'm just not sure that the judge, that the way it's expressed in the decision is quite as nuanced as yours is.
Certainly, Your Honor. The other, that was with Judge Troy's summary judgment decision. That was not the only foundation for his decision to enter summary judgment on behalf of the Commonwealth. He dealt first and primarily with the issue preclusion. And so if the court were to decide this on issue preclusion, then it would simply not even need to reach whether the innocence requirement, as phrased by Judge Troy in the summary judgment decision, was perhaps overbroad.
Issue preclusion and causation.
Well, issue preclusion, he does address it as a causation issue, at least in part as to the issue that was the first element of the issue preclusion. And I'd just like to turn very briefly back to your question, Justice Botsford. The Powell decision cited by both the plaintiff appellant and the amicus, I think identifies a situation more like what Justice Gantz was talking about, namely where somebody agreed to plead to something that was lower, but was instead ended up pleading out, not only getting sentenced to something higher, but in fact pleading out to something higher, which is, I think, the polar opposite of the situation that we have with Mr. Alicea here. Turning, though, to the issue preclusion, there are 5 questions that the court addresses when it's presented with a defensive, or in this case, the use of the defense that the Commonwealth put forward of issue preclusion. The first is whether or not the issue litigated in the 2 actions is the same. And obviously the 2 actions here are this state court action and Mr. Alicea's prior federal court action that he brought initially against both the Commonwealth and against his individual public defender. That for the Commonwealth obviously was dismissed out of the federal court action under the 11th Amendment. Mr. Alicea then filed the immediate state court action. The federal court action, however, continued through discovery, summary judgment, a grant of summary judgment in favor of the individual public defender, and was affirmed on appeal by the First Circuit. The issue litigated in that federal action was whether or not the erroneous entry of the Knoll Pross entitled Mr. Alicea to a 1-year prison sentence. And
Well, actually, the question was whether there was a conspiracy to violate civil rights, of which the violation of civil rights would be the deprivation of the 1 year.
That was certainly the claim, and the issue that underlay that claim was whether or not there was a right that was violated. And the First Circuit, in its decision affirming the summary judgment grant by the district court, found that there was not a right to a 1-year sentence. So even had there been a conspiracy, there wasn't a right that could have been violated. So the issue was whether or not the erroneous entry of the Knoll Pross entitled Mr. Alicea to a 1-year prison sentence, and the First Circuit determined that it did not. And that is precisely the issue that Mr. Alicea intends or attempts to relitigate here. And in fact, as Judge Troy wrote in his decision, and I believe, Justice Spina, this goes to your point about causation, that the Alicea cannot show, and this is at page 142 of the appendix, that he was harmed by McGuire's conduct if he was not entitled to 1 year in prison. And so the issue is the same, whether or not the erroneous entry on the Knoll Pross entitled him to 1 year in prison. So the first question of issue preclusion is satisfied. Second is whether or not the issue was actually litigated in the federal action. It's very clear from the First Circuit's decision, which is at pages 107 to 109 of your appendix, that this was something that was in fact litigated. The First Circuit quotes Mr. Alicea as saying that he had a right as a result of that erroneous nolle pros to the 1-year prison sentence, the same thing that he attempts to litigate here. So obviously the second question of issue preclusion is answered in the affirmative. The third is whether or not there's a valid and binding final judgment. Mr. Alicea does not dispute that the First Circuit's decision is in fact such a valid and binding final judgment. And the fourth is whether or not that issue was essential to the decision in the earlier action. Clearly it is, for the reasons that we were just discussing, Justice Gantz, namely that whether or not there was a right is fundamental to whether or not there could have been a violation of the right. And if there was not a right as a result of the erroneous nolle pros to the 1-year sentence, then there couldn't have been a claim there. So it's essential to the disposition of the federal civil rights action. And finally, the fifth issue on that is whether the parties are the same or in privity. Clearly here, the party, Mr. Alicea, is the same, and the party of the Commonwealth and the public defender are in privity because, as Judge Troy noted in his summary judgment decision, the negligence claim against the Commonwealth is essentially an official capacity claim against the individual public defender. Therefore, the parties are in privity. But going next, so obviously for issue preclusion reasons, we would urge the court to affirm the summary judgment grant in favor of the Commonwealth. But
And is it your view that if we say there is issue preclusion, we need not reach the issue whether the First Circuit was right?
Right about which part, Your Honor?
Right about whether or not there was the possibility that still remained to proceed under a 10A or a 10G?
I think if you determine that the First Circuit has in fact dealt with these issues, then you wouldn't necessarily need to address that. But I think the First Circuit is right and citing to, I believe it's the Rollins decision, noting that the entry of the nolle pros, and in fact, as my brother has conceded in his argument, that the nolle pros would not bar re-indictment on the 10A charge. That the court, having realized the mistake, and obviously this would have been the preferable route, the assistant district attorney could simply have re-indicted on the 10A, and they could have proceeded back to the plea.
And I guess that goes to, do we have any cases in which a person fires a gun outside his home and then brings it inside the home, is immediately arrested, charged with one, could be charged with 2 crimes, with 10A and 10H because he fired it outside and then brought it inside?
The 10H charge, I believe, Your Honor, was actually the unlicensed possession of the firearm. The 10A, which is based on the actions of the firing outside, are 2 separate things. One is the possession without the license to do so, and the other one is the actual act of firing the weapon.
10A is the possession, is the license to carry, isn't it? Is not?
I believe, Your Honor, that the 10A was which was the one that they intended for him to plead to, was in fact it was the discharge, but I could be wrong
No,
about
I
that.
think you're wrong on that. I think it was the license. It was basically it was illegal carrying without a license to carry versus illegal possession without an FID card.
And
Now let's assume here that the facts are as reflected in that there was firing outside, which would suggest possession outside the home, then brought inside the home. Can you charge both? Can you charge because he possessed it outside in violation of 10A and then immediately thereafter brought it into his home in violation of 10H?
I don't do criminal law, Your Honor, so I'll start with that as a disclaimer. I'm not aware of any cases where that's the case, but I simply haven't looked at the issue. If the court would like, I'm happy to do a little bit further looking and do a 16L letter.
But you're also saying that we don't need to do that because the First Circuit did that itself, and we can just say that's precluded by their finding.
This issue has already been fully litigated. The plaintiff appellant has lost on this issue, and we don't need to revisit and give him a second bite at the potentially inconsistent judgment. Turning quickly to the question of the malpractice, however, while the plaintiff appellant argues that the innocence requirement need not apply if an error happens in the context of sentencing, that simply isn't this case. This case is about what the defendant, the former criminal defendant, now plaintiff, pled to. It's a question of what did he admit guilt to, not a question of what his sentence was. all the parties, as is clear, I believe, from the affidavits submitted from both the ADA and the public defender, which are included in the appendix, I believe, starting at page 110, that the parties all intended that he would plead to the lesser included of 10G for a sentencing recommendation of 3 to 5 years. The plea colloquy, that's also the transcript of which is included, also makes that clear. And in fact, at page 75 of the appendix, prior to accepting the plea, the sentencing judge, the judge taking the plea, who ultimately imposed the sentence, asked Mr. Alicea whether he understood that the parties were recommending a sentence of 3 to 5, and that was the judge's intent to impose such a sentence. Mr. Alicea indicated that he understood that. It's not until 2 pages later, at page 77 of your appendix, that the judge, in fact, accepts the plea. So the question is, what did he plead to? And even the motion to amend changes the plea, not the sentence. So the question is, to the extent that there was any erroneous procedural mistakes made by the ADA or the public defender, they apply to what he pled guilty to, not to what his sentence was. And in fact, what the parties did was an effort to secure the plea that Mr. Alicea had begged his public defender to work out for him. And for those reasons, we would encourage.
Can I just ask you,
Certainly.
I mean, it appears that on page 79 of the colloquy, that that the clerk read that that on count number 3, charging you with possession of a firearm, the court having accepted your plea of guilty, the court finds you guilty. Now, that's what he pled to.
He pled to the 10A portion. The facts that he, the plaque.
You're saying 10A is possession of a firearm?
I'm saying that certainly what the parties intended was for him to plead to the 10A. And
Carrying, it's not possession. It's not possession in the home. It's
carrying outside. And I believe that the facts that the assistant district attorney, and I'm sorry I'm over my time, the facts that the assistant district attorney recited are at pages 69 through 70, and those are the facts that Mr. Alicea agreed to, which included the firing outside and the discovery of the wet footprints leading into the residence.
But the ADA at the beginning of the plea said he's pleaded guilty to count 3,
Which was 10H.
which was the 10H.
And which was obviously is clearly something that was erroneous given the statements both by Mr. Alicea in his deposition and the 2 affidavits submitted by the assistant district attorney and the public defender in this case. We would urge
Thank you
affirmance.
very much.
Thank you, Your Honors.
We'll take a brief recess.
All rise.